we will discuss the exceptions to the doctrine of indoor management, or you can say the exceptions to the doctrine of torque and rule, because torque and rule and doctrine of indoor management is the same thing. Uh, in the time being, doctrine of indoor management is also subjected to the certain exceptions. In other words, relief on the ground of indoor management, that was the remedy in favor, or you can say, uh, you know, the rescue for the third person who was dealing with the company from the very harsh principle of the indoor constructive notice. There are some exceptions that have been developed with the time. The first one is the knowledge of irregularities. See, the very premises, the very basis of the Torquand rule or indoor management is that how the outsider can know the internal proceeding, the internal management of the company. And so for the outsider it is always presumed that the internal managemental or internal managerial activity has been completed. But suppose the outsider have the knowledge, okay, so that in that case we are not saying कि constructively we are imposing, he has the actual knowledge. So the first exception is the knowledge of irregularity or the actual knowledge of irregularity. Suppose in the like in our first case Royal British Bank, or in the second case Freeman versus Lockyer. Suppose in the Freeman versus Lockyer, that company of architect, that company of architect and planning have the knowledge that this person K, who was acting as the managing director, was not actually appointed as the managing director. And even after that knowledge that he is not the managing director, and as per only the managing director can bind, he is just showing that he is the managing director, but he has not actually been appointed. In that case, indoor management would not be helpful, because indoor management would against be or would create the injustice. If you remember, I have told that the doctrine of indoor management has the rationale of justice and convenience. So, when application of that doctrine would result into unjust ending, then that must not be applied. So, when a person dealing with the company has the actual knowledge, or sometime when the person is within the company, so in that case even the constructive knowledge of the irregularity as regard to the internal management, he cannot claim the benefit of this doctrine of the indoor management. Sometime a person dealing with the company may be himself be the part of internal proceeding. Suppose the person is the director, and the director has the knowledge, and the director dealt with the company or made the contract with the company. And in that contract, suppose there is any irregularity with respect to the uh, you know the binding effect of that particular contract, and that irregularity was not present in the public domain as as the part of the articles of the association. But because this person is the part of the company and he has the actual knowledge, and despite that actual knowledge he made that contract, though he was aware that it was not actually as per the authority. So in that case, doctrine of indoor management will not be helpful for this person, and the exception would apply. The second is the forgery. See, in the this case, uh, Freeman versus Lockyer, suppose the person who shows him as a managing director, okay, he ostensibly, he apparently shows that he is the managing director. He was the director, that is fact, but he was showing he is the managing director, in even the board of director has not restrained him. and so the court even applied the holding out. Suppose we change this, the facts of this case with, suppose there is third person, okay, he even not the director, and through the forgery he shows that he is the managing director through the forgery. So any person that is not related to the company show that he is the managing director. In that case, you know, the person, the outsider cannot take the defense that as per the articles of the association there can be managing director, and managing director make the contract, this type of the contract, and whether the person is actually managing director or not is the internal affairs. No, this cannot be applicable, because you know the forgery or any type of the fraud would not create any title. So when the act is done in name of the company, and that act is through forgery, so it would be void ab initio. The doctrine of indoor management does not apply. And so where the person relies on any document that turned to be forged, nothing can validate the forgery. And it is not that the title of the person is defective, but there was no title. So in the Freeman versus Lockyer, the person who shows him as a managing director, but he was not duly appointed as a managing director, there was the defect in the title. But a person other than him or any outsider who was not even the director, through the forgery shows that he is the managing director. In that case, there is not the question of the defect of title, but he having no title at all. Then the third exception is negligence. Negligence on the part of third person. The third, suppose there is a third person A and who make a contract with a company B, and how the company can make the contract, you know, uh, articles of the association have some rules with respect to that. Even if you read Companies Act section 24, section 24 also having some rules with respect to the company, that who can bind the company. Okay, then there is some suspicion, maybe the person's name is uh, Firoz Ahmed, but he is signing like Vinod Kumar. So this type of the suspicion or any other type of the suspicion, suppose he got, okay, and then as a prudent person, there is the duty or expected that when there is any suspicion, then the prudent person will inquire in that case, and the third person has failed to do it, then also the court in cases has held that because there is the negligence on part of the third person, the constructive notice would not apply. It's not saying that the constructive notice will apply, or it's not saying that the doctrine of the indoor management is on the justice and convenience. But in this particular situation, when the outsider, we are not presuming, court said that we are not presuming that the outsider must know internal proceeding, but if they see any suspicion, in that case a prudent person may make the inquiry. Nahi bhai sahab ruko, I will make the inquiry that actually you are the managing director duly appointed or not, और उस केस में इंक्वायरी की ज़रूरत होती है. सो इन दैट केस when there is negligence on part of the outsider, in case of suspicion of the irregularity, then also the doctrine of indoor management will not apply, and as an exception, the judgment will be in favor of company. So when there is apparent irregularity which could have been discovered by the inquiry, the doctrine of indoor management does not apply. Similarly, the protection of the rule is not available where the circumstances surrounding the contract are so suspicious as to invite inquiry, and the outsider dealing with the company does not make proper inquiry. And then there is the case, the Hogston and Company, Nodart, Law and Well Limited, 1927. Hogston and Company, Nodart, Law and Well Limited 1927. I will write these cases, this case and the another case on your the class Google Classroom, so from there you can learn. So here in this case, a person was director in two company, and he agreed to apply the money. He borrowed the money, and he was borrowing the money being the director in one company, and he was saying that he will use that money for the purpose of another company. So this is very suspicious circumstances. One person, he was director in two companies. Suppose there is a person X, and he is director in company A and the director in company B. He approached to a person C, okay, and said that on behalf of company A, I need this much of the money. And when there was the discussion that where you will use, so he said that there is some liability in company B and I will use that money for the B. Here the circumstances is so suspicious that the person who taking the money, and by that he is making the contract on behalf of the A, how he will use that money in the B. So in that circumstances, a prudent person must inquire, and that in that case it has not been inquired, and so the court said that this is the perfect case of the the exception to the indoor management. The fourth one is the representation through article, or yeah, Abhishek, I will come to your question also, or acts within or outside the scope of the apparent authority. See, I have said that when you read the Diplock Learned judgment, the Diplock Learned judgment in the Freeman versus Lockyer, he has differentiate between the actual authority and the apparent or ostensible. So apparent or ostensible authority is the same. So when the agent has the apparent or the ostensible authority, and if a person is acted outside the ostensible authority, then in that case indoor management would not apply. If you again read that judgment of the Diplock Learned judge, the Freeman and Lockyer judgment, there are three judgment. You will find three judges judgment. So when you read Diplock Learned judgment, you will find he has differentiated between the the actual authority and the apparent or ostensible authority, and finally said that in this case the person has not acted outside the apparent authority. And so here from the exception, that what if that person had acted outside the apparent authority in any unusual manner, so in that case whether the indoor management would apply or would not apply. So here is the you know that the articles of the association generally contain the power of delegation, like the directors may delegate the management to one director, and that director would be known as the managing director. The actual delegation is the internal matter, and so if the act of the officer of the company is one which could ordinarily be beyond the powers of such delegation, the protection of the indoor management or torque control cannot be claimed. And there is one case on it, the Credit Bank Castle versus Scanger Limited 1927 King Bench. This case also I would write on the Google Classroom. A branch manager of the company carrying on a business as a forwarding agent purported to draw bills of exchange on behalf of his company, which he subsequently endorsed on their behalf. It was held that having regard to his position, drawing of bills was not in his apparent or the ostensible authority. Apparent or ostensible is the same, okay, authority of the branch manager, and therefore the company was not bound unless it had been given him the actual authority, or otherwise otherwise precluded from setting up the want of authority. It does not matter that the plaintiff did not know the article giving the power of delegation. So suppose in case of the branch manager, what is the power? Only that function if the person is doing. In that case, whether that person is actually being appointed or not, if there is question, in that case the indoor management or torquent rule would be helpful. बट इफ़ द पर्सन इज एक्टिंग एज द मैनेजिंग डायरेक्टर और उसने जो काम किया वो उस मैनेजिंग डायरेक्टर की अथॉरिटी के बाहर का था, सो इन दैट केस इवन दिस ग्राउंड दैट आई वाज नॉट अवेयर दैट दिस पर्सन वाज ड्यूली अपॉइंटेड, बिकॉज ये इंटरनल प्रोसीडिंग है, दिस एक्सक्यूज विल नॉट रन, इंडोर मैनेजमेंट विल not be helpful. And the the defendant company by its memorandum had the power to draw and accept the bills of exchange, and by the articles the director were empowered to determine who shall be entitled to sign, draw, accept the bills.